Well, about 2 years ago, I was involved with the Change Project from Research in Practice, Social Work and the Use of Evidence in the Family Courts, and several incentives came out of that. One of which was a court skills competence pathway.
Being involved in the Change Project and using the action pack with its focus on tools and its detail and its enhancing of confidence meant that scrutiny was given by social workers from beginning to end, and so therefore a much clearer and more knowledgeable analysis was presented to the court, and that can help to prevent delay. Because the social worker is clearer, they know exactly where they're heading, they're focused, and the courts are happy with that. That's what they want.
One of the things that we've been trying to introduce in the middle of a whole kind of strategy for improving the credibility of social workers in court is for social workers to use research in anything they do, not just in court work, but to underpin their analysis in assessment and in care plans, to underpin it with research.
The change has been primarily around confidence within the staff themselves, within the organisation, confidence from the higher echelons of the organisation right through to social work assistants, but confidence in the for the judiciary in the social work profession as well. And that's that has caused a sea change. There's been an organisational change in culture, an enthusiasm and an energy that hasn't been seen before.
I think on the whole, most social workers here give their evidence extremely well. So broadly speaking, I'm more than happy with what they managed to achieve. I mean, inevitably, a bit like judges, some of them are better at expressing themselves than others. But that's inevitable, it seems to me, depending on the individual.
There are some social workers who clearly follow the research as it's developing and will cite it in a manner which demonstrates that. Others will cite a piece of research in a manner which leaves you with no great confidence that they've really read and understood it. To be useful, there needs to be a reference to the material, and because most of it will be in sources which are not readily available to me, it is desirable that I should be provided with a photocopy of at least an abstract, if not the full research document.
The most important thing is to listen carefully to the question, not to answer more than the question, and to speak out loudly and clearly, but at the same time always to give the appearance of being balanced and fair in what you say. Certainly not minding saying strong things when they have to be said, but equally being prepared to concede points if they should be properly conceded.
Social workers are expert witnesses. The distinctive characteristic of an expert witness as opposed to a witness of fact is that the law allows an expert to express opinion, and that is what social workers do all the time, and they should be treated as experts.
I've actually had some experience of social workers using research really well in court proceedings. There was a case that I dealt with which was very finely balanced in terms of the contact levels for an older child. And I was dealing with a very experienced social worker, but she was very reluctant, as I recall, to deal with that by the use of using evidence. But I actively encouraged her to do that, and in conjunction with a social worker from Bath, she obtained all the recent evidence in relation to contact levels, and we presented that to the court, and we had a very positive outcome as a result.
I had a case very recently where we had a dad with sexual offences against children. The social worker had found it interesting and had taken it upon herself to do some extra research. She bought a book, she'd been on a course, and so when she gave her evidence, because her father challenged it, she gave her evidence, she was very clear, she backed it up with the research that she'd done. She was asked specifically, how many cases have you done where you have assessed potential risk from a man like this? And she said, this is the only one. And she was very open and said, this is the only one, but this is the work that I've done. And she was able to quote chapter and verse. And so she actually preempted the father then being able to make a further application, because the judge said, well, why would I need anything else when I've had this evidence in front of me?
One of the other issues is that of balance, and the local authority really does have a duty, in my view, to present all of the evidence to court, not necessarily evidence that just simply supports their case. At the end of the day, they need to put in the negative evidence, the information that would justify the court making an order to remove the child or to make a particular type of order. But also they have to put in the positive aspects that the parents have shown. And that shouldn't just be a lip service, the parents have done particularly well in contact. I think there needs to be quite a decent amount of information in there that does highlight the positives as well as the negatives. So I think that really the information has to be very balanced.
Sometimes people have found research that actually goes against what they were planning to do with a child, and so their plans have changed. And I think that is really significant, that you look at the research and you don't find the research that backs your story. You find the relevant research and use that as a hypothesis to work out whether you're going in the right direction. And sometimes we're not.